Hello and welcome to this week's LLG Brief. I'm Deborah Evans, the Chief Executive, and our topic of the day is consultations in and out of lockdown. Now, it's been an incredibly complex time for consultations, with social distancing requirements meaning that it's impossible to do things the way that they would have been done before. And are online consultations the only way that you can then get engagement with your community? Well, to help you wrestle with a number of these very difficult questions, we have some experts with us today from BDB Pitmans. So firstly, we have Stuart Thomson, and secondly, we have Matthew Smith. So without further ado, I'm going to pass over to our special guests to take you through today's presentation. Thank you.
Thank you very much, Deborah, and good afternoon, everybody. Thank you very much for joining us for this briefing on consultations in and out of lockdown. My name, as you've heard, is Matthew Smith, and I'm a partner in BDB Pitmans' public law team. And I'm joined today by my colleague, Stuart Thomson, who will just say a couple of words to introduce himself.
Yeah, I'm the head of the Public Affairs and Communications consultancy that BDB Pitmans has, and I've been doing sort of community engagement work and reputation management work for sort of over 20 years. So hopefully we can share some top tips and best practice today as we go through the presentation, and obviously questions at the end as well.
Excellent. Yes, thank you very much. And this first slide is, as you can see, just to scope out the broad themes that we are planning to cover today as we talk to you. So we're going to begin by looking in a couple of moments at what worked well, or what has worked well, in terms of consultation during the lockdown periods that we have experienced so far, and equally what things might have worked less well in those circumstances. And then we're going to take themes of awareness, accessibility, technology, diversity, to try and tease out some of those issues and explore some of the problems that have arisen and some of the solutions that people have come up with, and perhaps just some of the things that those of you who are embarking on or involved in consultations will want to bear in mind. And we'll have a section of what we're going to say that looks at some very practical issues. And then some COVID case law, which sounds very unpleasant indeed, but in fact just 3 cases where the courts have grappled with some of the issues that have arisen specifically in relation to consultation during the period of the pandemic. And then we'll finish off with a bit of crystal ball gazing, trying to think about the extent to which innovations and developments which have occurred during this period of lockdown in terms of consultation might be carried across into the post-pandemic world. And if we could move on now to the next slide. Before we launch into those topics that I've just outlined for you, we thought it was useful just to remind you of the core requirements of consultation insofar as they're set out in the Gunning principles set out on this slide for you. Now, it may be, indeed I expect that the vast majority of people listening to this webinar would be able to recite the Gunning principles with their eyes closed perhaps, or perhaps even in their sleep. But nevertheless, we thought it was helpful just to put them here so that they're at the forefront of all our minds as we think about the extent to which these principles, or at least some of them, are still in play and still relevant to consultation in the pandemic situation. We're also going to consider, against that backdrop of the Gunning principles, the extent to which consultations carried out in the pandemic environment have to be adjusted and can be adjusted, notwithstanding the Gunning principles. And then, as I mentioned earlier on when we were talking about the agenda, the agenda for today's discussion, we are going to think with reference to 3 specific cases about how the court has approached those Gunning principles.
Next
So
slide.
over to Stuart, I think.
Yeah, the next slide hopefully as well. So what we thought we would do first of all is, rather than sort of us deciding what people had thought about the consultations they'd conducted and the challenges that they'd faced so far during COVID, we'd actually ask some real people that have actually had to do the jobs. So this first comment comes from a consultation officer. We've suitably anonymised the comments for fear of embarrassing them or anything like that. And they said COVID has accelerated and opened up an innovation and virtual digital by default, and people are ready, judging by the numbers that we're getting for their surveys, which is always a reassuring sign. So yes, we can't miss out people and non-online poses challenges. But I think the early signs are that this is good, and around 9-fold more during COVID. Many communities embracing virtual, and one did a fab YouTube video themselves. So I suppose what this starts to tell us is that you need to keep that requirement to reach out to those not online as well. Again, it comes back to the principles, which will be the constant theme of, as Matthew has mentioned, of what we talk about sort of during this next hour. But the evidence suggests that people are willing to engage in consultation remotely. And the thought process that we all have to have is that will actually continue post-COVID, as opposed to pre-COVID or even before. In other words, is the situation likely to go back to what it was, and the traditional mainstays of consultation? Probably not. Next slide, please. Second comment, longer. I won't read this all out. You can read this in your, you can flick through it. I mean, I think again, what we're sort of looking at here is different consultations and how they've come across a variety of issues. So, the idea that no two consultations are ever the same, well, that applies equally to the online challenges as it does to the real world, challenges as well. And similarities in the process, this particular person is calling out. So there's no uniformity of experience with these things. So again, you might think that's sort of borne out by the reality of your consultations, the ones that you've been involved in as well. And there are definite practical problems, again, which we'll talk about during our time today, and practical problems, especially during the middle of a pandemic, that was seen as sort of relatively straightforward in the old way of the world, a bit more challenging now. This particular person has found lower overall engagement as well, but a better take up virtual events than was achieved at face-to-face. So again, are people really want to go back to the old situation? To be honest with you, probably not. And next slide, please.
So we mentioned earlier on that we would have a think about what had worked well in lockdown in terms of consultation practices, the approach to consultations, and we'll start here just looking at some positives in a very high level way. Positives which have emerged from the way in which consultations have been approached and carried out in the period of pandemic, and then we'll develop some of these themes in a bit more detail as we go through the webinar. So if we take the first two bullet points on this slide together and look at accelerated innovation and new ways of working, in terms of accelerated innovation, I think it's right to say that not just in the world of consultation, but more generally, people have been given a kickstart and forced to embrace innovation that they might have been thinking about using in the pre-pandemic world, but with the onset of pandemic have had no choice but to embrace that innovation and see how it can be brought to bear for the benefit of various tasks that we have to carry out in our normal lives, including consultation. And so we've seen, just to state in some way some of the obvious things that all of us, I hope and think, will have been aware of over this period, a much greater uptake of digital platforms, new ways of working using those platforms. So we're all now, I think, pretty much conversant with Zoom. ZoomMe is now a term of art in the same way that CallMe used to be. Equally, other platforms are available. We have MS Teams, We have YouTube as well, which of course was there pre-pandemic, but the uptake of that and the use of that in the context of consultations has been quite striking. And also, as well as just the platforms, we've seen a great increase in the use of digital tricks, if you like, the tricks of the trade in the digital world. So things like virtual consultation rooms, breakout rooms to allow smaller discussions, facilitated discussions, the use of poll questions to take the pulse on particular proposals, snapshot pulse there and then, and online surveys as well. All of those things are now becoming part of the normal consultation discourse in a way that they might have been in some programs, or some of those tools might have been used in pre-pandemic consultations. Not all of them, and nowhere near with nowhere near the same frequency now that they seem to be being used in these pandemic times. We've seen an increase in the attendance of people at some consultations. Obviously, the views that Stuart just outlined for you suggest different experiences about this, but there is data to suggest that there has been increased attendance by virtue of putting consultation exercises online, and there are a number of reasons for that. Perhaps people can attend, in quotes, events from the comfort of their own home. They can cut out the travel on a cold night to a distant venue, and they're able just to log on and be present in the discussion. And equally, we think that there is a clear phenomenon that people, some people at least, will prefer the anonymity of an online environment, and that can be achieved in a number of different ways. But quite simply, it may well be possible for you to sit there, participate in a consultation from the comfort of your own home, as I say, but off camera, and not revealing your presence to those around, which may also encourage people to contribute to the discussion on an anonymous basis in a way that they might not if they were sitting in a physical environment and their comments would be immediately attributable. We touch here on greater diversity, and we'll look at that again in a bit more detail later on. But virtual consultations, we think, can reach parts of the community which other consultations may not be able to, in danger of paraphrasing an old beer advert there. But there is data again to suggest that the reach of virtual consultation is greater and more effective, certainly in respect of certain groups that are perhaps underrepresented in non-virtual consultations. And then finally, a positive and a distinct positive, and not one to be overlooked simply because it appears, or I mentioned it last on this list, avoiding the burdens and costs of pre-pandemic consultation practices. And we can think here immediately of avoiding the costs of booking out venues, which can be very significant indeed. And also potentially, at least, avoiding some of the costs associated with printing hard copy documents, although those costs, as we'll see in a later part of this webinar, are not likely to be avoided altogether, and one certainly shouldn't plan on the basis that those costs can be removed from your consideration altogether. Next slide, please.
Thank you. But of course, the positives, there are the negatives as well. The most obvious one of being is the risk of exclusion. So if we're all moving to a sort of an online way of doing consultation largely, then there are parts of the community that may well be excluded. Now, obviously, the challenge of sort of seldom heard, or what used to be called sort of hard to reach groups in the previous consultations, it's the same challenge, but it's the platform that's altered. So how are we overcoming that? What are we doing to get to those groups that aren't immediately able to use those various online platforms, which we've all had to rely on because we can't physically meet? Second thing is actually, look, I mean, as Matthew mentioned, there are various platforms, including GoToWebinar as well. Didn't want to miss that one out, seeing as we're on at the moment. But we're all pretty annoyed with online platforms. I mean, there's the general sort of technology issue side of things, but there's that fatigue as well. If you're staring at a screen all day for work purposes, and this is the only way that you can communicate with colleagues, the idea of jumping onto a Zoom call or doing something else about consultation in the evening may not hold a huge amount of traction. So I suppose what we're trying to say is, look, there may have been some initial novelty value, if we can call it that, for doing some of these things. That might not last. So some of those things that Matthew mentioned about breakout room types of discussions that are available, but actually we just all got to get more used to using all the various tools that are available on the platforms, but also varying it as well. Something a bit more professional, more use of films or something like that as part of calls as well. So it's not just people like us presenting some questions at the end in a breakout room, or we're all together and then we think we've done the consultation. So the expectations of those platforms have changed and are changing over time. And it's those technological barriers as well. It's all very well and good putting them on the, having these sessions, but everybody's Wi-Fi, with the best will in the world, can be a little bit ropey. So you have to contend with those sorts of issues as well. And certainly you can put contingency plans in place and telephone lines to come into calls and things like that, but that has to be all part of that planning and that preparation. It's not just simply a case of, look, let's move it onto online. There are a number of challenges which come with that shift in focus. And whilst we have sort of costs as a positive, costs can also be a negative as well. We'll return to this at various points throughout today, but if we're having to make information available to people, how do we best do that? Now, we can do that online, of course, summary documents and things like that, but you might also need to think about producing larger hard copy versions of documents, because we can't physically place those in a location that communities can access because they're closed. So one of the thought process, one of the questions that we'll return to is whether you simply make those very large documents available, print them and send them off and things like that, in which case that cost suddenly starts going up. And actually the costs of Zoom and doing these things professionally isn't zero either. So there has to be some sort of budgetary allowance made for this new type of way of consultations, this new form of engaging as well. And there's the other side of it as well. So if you're sending more stuff out, people are sending more stuff in, managing those postal responses as well. So team implications, team as in physical team rather than Teams S, Microsoft. And does that all take a little bit longer? So again, some of those challenges that have worked less well as a consequence of having to do consultations this way round. Next slide, please. And that brings us on to the challenge of awareness. So our sort of first big broad theme that Matthew mentioned at the start. And this is where I always think you could say that as a non-lawyer and as a communications person, I would say this anyway, but I think this is where the role of communications generally really sort of, kicks into gear, because getting the basics right of a consultation, whether it's virtual or, virtual, online, in person, whatever, are fundamentally the same. You still have to get awareness, you still have to raise awareness of the consultation, and you still have to tell your communities what the plans are, how they can get involved, etc. All those, they don't change. So with or without COVID, that's still the same. And that means getting information and getting to the right people at the right time, making the information available, making it available in a way that's accessible, and all those other points which Matthew will return to as well. And sometimes, particularly senior teams in any organisation, including local authorities, will sort of say, well, look, let's have a more social media type approach to these things instead. But again, if your audiences, your communities aren't there, then frankly, sticking a load of tweets out across Twitter or posting stuff on Facebook or LinkedIn or whatever it happens to be, whatever the platform of choice is, if you're not communicating with your community, then it's pretty ineffective. So you have to come back to some of those principles, first base principles of communication, to make sure you're raising awareness, and particularly with social media, frankly. Look, a lot of the time, you know, projects struggle for things to say over a period of time, whereas actually social media can be really quite content hungry. It wants engagement, it wants people to respond, you know, it wants new bits of information out there. Is your consultation really in a position to be able to do that? Can you really hand on heart allow your teams, you know, across any organisation, across any authority, the freedom to be able to do that? So the freedom of social media sometimes can produce quite challenging environments, particularly for lawyers. You know, sometimes it's also quite useful to go back to some of those first principles about your own statements of community involvement as well. So let's take it back to that. Let's think about how we're going to all engage with those audience that we as an authority have already identified. Now, of course, those statements won't have been sort of COVID proofed in that sense. But again, it's worth going back to those first principles and thinking about, you know, the people you are engaging with, and then how you get to them. And some authorities and some organisations have gone for more sort of novel routes. So, you know, think about online advertising, for instance. But actually, if you think about it, the mainstays of how you engage with a community through local community groups, through you know, well-placed stakeholders, through the local media in particular, these are all pretty similar. So I suppose the first point is slightly challenging in the sense that actually, whilst we're online, has the fundamental starting points of your consultation actually changed very much? Next slide, please.
This is where I jump back in, and you'll see I'm conscious that we are speaking here to an audience of lawyers, and that you are likely to be very familiar with the content of this slide. And they say, don't they, don't put too much content on any one slide, and you'll see that I've completely ignored that golden rule in relation to this. So my apologies for that, but in my defense, the key things that I want to remind you in relation to the public sector equality duty, which obviously is pivotal in so many consultations, are picked out in different colour text here. So we really wanted to emphasise the fact that the duty requires that due regard is given to the need to do various things, and in particular advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share that characteristic. And that, I think, we're going to look at particularly in the course of what more we have to say to you today. And then that sort of core duty is buttressed by the further need to have due regard to the need to do certain other things. So remove or minimise disadvantages suffered by particular people, take steps to meet the needs of those persons, and thereby encourage them to participate in the context of what we're saying today, in public consultation, to be able to play a full part in that. And then I think the final thing I want to draw attention to, although it's not picked out in differently coloured text, so my apologies for that, is the fact that we're focusing in relation to the public sector equality duty on protected characteristics, as I've mentioned already. And there's a whole range of those characteristics, as you will know, but in particular we're going to be thinking, I suspect, in what we're going to say to you in what follows, about age and disability. So on to the next slide, please. And this takes us to our next major theme, which is accessibility. And there are a few really important things to say here in relation to accessibility, and I think accessibility as a theme straddles more than one of the gunning principles that we talked about earlier on. So, you know, first and foremost, it's about making sure that the relevant information is imparted to those you are consulting to allow them to understand the proposals and to make reasonable, sensible, well-informed comment on those proposals. Now, obviously, that benefits consultees, but it also benefits those who are consulting, because the quality of the responses that you get will be much better if you're successful in that aim. And lockdowns have shown us that a large number of previously face-to-face activities could be successfully transferred online. The vast majority of households do in fact have internet access and or access to a smartphone. And there's an interesting stat at the bottom of this slide, which is in very small print. I apologise for that. But 87% of households have internet access, and 79% of those households had a smartphone, according to Ofcom in 2019. So relatively recent data about that. There's often a concern that online activity will miss out a big chunk of any given community, and of course there's a risk of that, as Stuart's already mentioned, but it can be overplayed, and those stats I think are quite striking in terms of the access to and availability of virtual online tools. Virtual consultations can help more people to attend a consultation event for reasons that we've touched on already. And having said that, there's a relatively small number of people, who won't be able to access things in the remote realm. Nevertheless, it's important that we continue when consulting to think about those people and how we do get the message out to them, how we can make sure that they understand the proposals equally as well as those who can access online, and have an opportunity to respond sensibly to the proposals. And it's well known that device ownership, for example, is lowest in those over the age of 75 and those in the D and E demographic groups. So that's semi-skilled and unskilled manual workers and pensioners or lowest grade and casual workers, or those unemployed on state benefits only. Those groups we know will tend to be the ones who don't have the sort of access that I've just been talking about to the internet or smartphones. Some consultees will have limited internet bandwidth, and we know that that's a live issue in the UK. The availability of or the access to the internet, the quality of that access varies considerably across the country. And you need to think, therefore, about the size of documents that you're asking people to download, because that may present problems to them. While in theory they may be able to gain access to that material, in practice the speed of internet is insufficient to allow them to get that document in a readable form and digestible form in any sensible period of time. So there are a number of ways that you can get around that. Obviously, most obvious ones are to allow people to make requests for hard copy material, or to provide them with the material on a USB stick. Now that can't be an open-ended offer, clearly, because you've got to manage costs, and I think Stuart's going to talk a little bit more about that potentially in relation to a later slide. But they may be ways that one can overcome the problem of not being able to access material online, notwithstanding the fact that people appear to have the ability or the core tools to do so. Remember that in terms of the expression of views, I talked earlier on about the potential benefit of being able to express views anonymously. That may not be something, even if you reassure people that they can do that anonymously, it may not be something that they feel comfortable in doing in an online forum or environment. And so again, providing ways for people to provide their views by means other than online channels. So the obvious examples, to provide them by post, to telephone interviews, then those things do still need to be made available, and people need to be aware that they can communicate in that way. They mustn't feel that they are required exclusively to use the online methods of communication, channels of communication. Equally, and going back to my earlier comments, it is possible in many online environments to ensure that comments are shared anonymously. And if you can give people the necessary reassurance about that, then they may feel that they're willing to contribute, notwithstanding that it's happening online, provided that their name and face is not attached to the comment as it's made, or it's not attributed to them later on, directly at least. It's important, really important, to be aware that virtual consultation, in our view, imposes a greater burden in many ways on consultees to take responsibility for understanding what the proposals mean, because you've taken away the capacity to have a physical face-to-face meeting, or it's been taken away from us rather in the pandemic. And where sometimes those sorts of discussions are really useful to drill down into what somebody's genuine concerns are and be able to explain proposals in a way that reassures them, that can be very much harder to do in the virtual environment. And it will have a knock-on effect potentially to the quality of comments that you get, responses that you get to your consultation, because people may not grasp the nature of the proposals or understand their full implications, but may rely on somebody else's summary of those proposals or their own incomplete understanding of them to then shape the responses that they provide. So again, it's really important to do your utmost in these testing situations when you're consulting to convey the message in a way that hits the mark for every member of your audience. And obviously that's an extremely difficult task, but it hasn't really changed as a result of the pandemic, but perhaps we've got one or two opportunities to make that task easier, but equally one or two challenges, depending on the willingness of people to engage with the online environment. And Stuart, did you have any extra comments to make? I think you were going to add something on potentially allowing discourse on social media. Is there something to add on that?
Well, I think yeah, you're right, Matthew. I mean, on that, of course, social media is. I think it probably goes back to my earlier point about having the people and the skills and the freedom to deal on those sorts of channels as well, because as we all know, Twitter is not exactly a balanced and allows for balanced and nuanced discussion. So how do you deal with that? Again, you know, communications teams, your in-house teams across the authority will have expertise and experience in doing that. So maybe some of this is about actually working, as you probably already do, but thinking about the challenges that they face and building them into the design of the consultation as well. But I think, you know, it's any online discussion, through social media channels in particular, just very content hungry. They need an instant reaction. You have to staff that, and you have to capture that as well. So some of this seems maybe a bit boring and a bit processy, but the capturing of the way that you behave, the information, the exchanges, and the people become even more important, I think, during this particular time as well.
Great, thanks. So our next slide is continuing on this theme of accessibility, and I'm conscious of time on the webinar, and we've a bit of ground still to cover, but a few points to make here. Again, I don't think any of this will be earth-shattering, but it is worth just emphasising it in this relatively new environment in which we find ourselves. Certainly not earth-shattering to reveal that people with disabilities may face difficulties when they're accessing online materials, and there are legal requirements about the way in which websites must be presented to try and minimize the difficulties which those with certain disabilities may have otherwise in being able to take on board the information contained on those websites. But obviously it goes much wider than websites. It's about the nature of materials that are produced. It's about recognizing that there may be circumstances where you simply, you are faced with a person or a group of people with a particular disability, which means they're simply not going to be able to access the material remotely. And again, you're going to then have to think about other ways of making that material available to people. That challenge has always been there to some extent. The pandemic perhaps has just brought a sharper focus to it. And I think absolutely key, and this again is a piece of pre-pandemic advice, but which holds true for the pandemic period. Engagement with the seldom heard groups that you've identified in planning your consultations, and early engagement with those groups is absolutely crucial, so that you can understand what the difficulties are going to be, if there are any, and you can begin to identify collaboratively and cooperatively ways to overcome those difficulties, and that will save you potential criticism and challenge later on if you're able to do that. And it may be that again, none of these, I think, solutions are going to be things that nobody has thought about previously, but just making phone lines available, details of phone lines, whether that's to have a discussion about something, or whether it's to ask for material to be provided in a different format, providing material in different formats to pick up differing needs from those who need to understand the material that you're providing. And again, I think Stuart did have something to add on this, which was thinking about an app, and I'll just turn to him for a moment to talk about that.
Again, different forms of engagement. Think about what might be most useful. And the statistic that Matthew mentioned earlier about smartphone availability is that that's everything from making sure that if you are putting together a dedicated website or a part of the authority website for this particular scheme or service change or whatever it is you're consulting on, that's mobile friendly. There are some requirements around these sort of things, but actually some very practical requirements as far as your consultees are concerned. If they can't access the information you're putting up there properly, would be one challenge. Maybe having a dedicated app, maybe that would help. It doesn't have to necessarily have different sorts of information on there, but maybe you can do it in a slightly different way, more accessible. Maybe that enables you to put different types of content on there to engage as well, more video based rather than written content. But obviously there's a big emphasis on the power of the written word and documents, but maybe explaining those in a slightly more user-friendly way. Yes, summary documents, but why not summary videos of these things as well? And I think the other thing to mention about, particularly working with groups that represent those with disabilities or seldom heard groups, is that sometimes there is an emphasis on thinking that we have to come up with the ideas all the time. So, we have to design the consultation, or we have to have the radical, innovative, thought about how to solve these issues. Actually, there are representative groups locally and nationally who spend their whole days thinking about how the communities that they serve and represent, for instance in charities, can deal with these issues. So talk to them, work with them on what's current best practice, because that tends to change. So whilst the rules, if you like, and again, Matthew probably put me wrong here on the laws may not change in terms of some of the requirements around websites, although they do change over time, but expectations change. And if you're not engaging with those groups on these more general issues as well, you're going to miss changes. So don't think that you have to come up with the solutions all the time. Talk to these groups, work with them, and learn from their best practice and experience as well, is what I would suggest. I think that probably takes us on to the next slide, I think, as well.
It does. Thank you very much. Yes, this is our final slide on the theme of accessibility. And as you can see, we're making the link back here to Gunning 3, the third principle, Gunning principle, which, just to remind you, requires adequate time for consultees to consider and respond, and sufficient opportunity for participation. So thinking about that time issue in particular for a moment, there's one argument which says, while the public are distracted by COVID-19, and heaven knows we've been fairly fully distracted, as it were, or deflected by COVID for a significant period of time now. So the argument goes, the public is unable in those circumstances to give proper consideration to other issues, so the issues you might want to be consulting with them about, and therefore they won't have sufficient opportunity to participate effectively in any such consultation. Now, even if that's accepted as an argument, or there's some force to it, there's a question mark, of course, about the extent to which it will remain a relevant argument. In other words, how much longer we're going to remain in lockdown or something close to the length of time for which COVID will remain a live issue for us. Of course, we will have our fingers crossed for the vaccines and improvements in the near future to the situation, but it seems not unreasonable to plan for the fact that COVID is going to be part of people's thinking, and quite a significant part for some time to come. So I don't think we can simply say, well, let's discard that as an argument because we're going to be out of the woods as far as the pandemic is concerned in the near future. That wouldn't be a sensible position to take. That said, there is a counter argument, it seems to us, that people may have more time actually to think about the proposals on which you're consulting in the COVID period, the pandemic period, because putting it bluntly, there isn't anything else to do. People are not distracted by activities that they might in a pre-pandemic and hopefully again in a post-pandemic world be doing, like going to the cinema and meeting friends and all those things that we can dimly remember we were able to do at one stage in the past, some stages in the past. That there's a real willingness actually on the part of people generally to have things to take their minds off COVID. And actually we're seeing some evidence for that leading to people really giving focus to issues which perhaps didn't get the concentration that they're now getting in the past. So I don't think it would be right to accept the blunt argument that distraction by virtue of COVID means that people can't address their minds to other things. That simply isn't true. And of course, the reality is that changes will continue to need to be made in relation to a number of matters where consultation, the duty or a desire to consult is triggered, and therefore people are going to have to give their minds over to matters other than COVID at certain points along the way. It's not a viable position to say that consultation on anything can just stop because we're too taken up with COVID. So I think those conflicting arguments, those conflicting positions are interesting, but one shouldn't be stopped altogether from pushing ahead with consultation simply by virtue of COVID. Of course, you'll need to take mitigation steps to mitigate potential risks of conducting consultation in a pandemic period, and one of those obviously will be to extend the time that is given for responses to any consultation, and in a number of cases that's exactly what has happened. Again, though, consultation is a means to an end. There is a desired objective that those who are consulting are trying to fulfill, and of course if you extend the time for responses to be given, it's likely you will then push the timetable for the whole consultation back by a period of time, and that has to be balanced against the difficulties that they may cause, has to be balanced against the imperative ultimately of achieving whatever change it is you're consulting on, or implementing whatever decision it is you're hoping to make as a result of the consultation. Stuart, is there anything else you wanted to add on that? Again, I'm conscious that's an
No,
area that
no,
you're happy with.
crack on with the other things.
All of that? Okay.
Again, slightly conscious.
Good.
Oh, yeah.
Yep.
And again, here, I don't want to go through all of this list. I want to just pull out a couple of things. One in particular is the issue of security as well, because in fact, I won't embarrass the authority by naming them, but I was on a call recently where basically Zoom call got hijacked, and basically there was all sorts of unpleasantness shown on the screen, various inappropriate comments, etc., etc. So again, it's the technology. We just have to be aware of all these various elements to it, and security is one of them. The other thing which I just flag in terms of the technology is also when I say hijacking, when we say hijacking by campaign groups at the end, what we're thinking about there is if you are, for instance, making documents available, you just think, actually, look, the easiest way to do this is just to make the documents available to people. It could be that, if you've got a very group of sort of motivated opponents to your plans, everybody just sort of requests full copies of documents. So effectively, you end up becoming a printing house for these things. So those sorts of implications that we've tended to use, and certainly consultations that we've been involved in recently, is documents are available on a USB stick. Often they would be charged for during the course of a normal consultation, but during this lockdown, they're not. If you want it, here's the USB and here's the material. Next slide, please. Again, I won't labour any of these points. Most people don't have access to industrial printers that we all have at work. They can't actually physically print out documents. And again, if you go back to the point that Matthew's talked about, accessibility for different groups, it may not even be correct that that is the format that you want them to, that enables them to fully access the materials. So think about those sorts of issues as well. Can you accept the postal responses? Have you got a free post address or an authority address that you can use? Again, not difficult, not different, but just the practical steps that you need to think about in advance. So it's not just the business as we usually do things. Just everything's going to just take a little bit longer as well for these things. Next slide, please. Again, diversity, to be honest with you, I think we've sort of covered this in what Matthew and I have been saying sort of during the course of the time so far. So I think if we've got time, maybe we'll come back to this, but I think I'd rather sort of allow Matthew to move on with the COVID cases, I think, just at the end.
Okay, thank you very much. So we've got three cases that we thought we'd draw to your attention. I'm going to focus in a little bit more depth on this first case, the Article 39 case. The claim here is it's the first coronavirus-related consultation challenge to go to court. That may be right. It's certainly one of the earliest, if it's not absolutely the first. The challenge was brought by Article 39, who are a small independent charity that campaigns on behalf of children, for the rights of children in state and private institutions in England. The challenge itself was to the 2020 regulations that you can see that referred to on the slide. And the changes that were proposed were to introduce relaxations of 65 duties which were owed to looked after children. And those proposals were introduced against the backdrop of anticipated significant shortages of social workers and, of course, the then very fast developing but little understood threat of the pandemic of COVID. 7 of the of the relaxations that it was proposed to relax were said by Article 39 to have the capacity to create really serious consequences for the children whose rights they represented. And the basis of the challenge essentially was that there'd been a failure to consult on these proposals and particularly a failure to consult with the Children's Commissioner and other children's rights groups. And I'm going to refer to that group as the group. That's who I'm talking about, the Children's Commissioner and certain other children's rights groups. Next slide, please. So, as I've indicated, there was a claim for judicial review on the basis that there had been that lack of consultation with key groups. And a bit of a spoiler, straight away, in the High Court, the government, the Secretary of State, wins. In getting to the point where the judge reached that decision in the High Court, she acknowledged the state of knowledge and level of concern about the pandemic, which informed the decisions that were under challenge. In other words, she was cognizant of the fact that there was a pandemic, it was an emergency, and people didn't know at that time quite how bad it was going to be, but all the modelling was showing that it was going to be very bad indeed, and that as a consequence, it was pretty nigh inevitable that some of the relaxations that were subject of proposals for relaxation that were subject of challenge would have to be made. The judge also accepted that the proposals for change would not have a minor effect on the children in question. That there was some suggestion in documents which had been sent to the Secretary of State before the decisions under challenge were made, which sought to minimise or suggest that minimise the effects of the changes, or suggest that they would not be as extensive as other people, critics of the proposals, were suggesting. And the judge basically rejected that proposition and said no, they would have a serious effect, but nevertheless the changes were being proposed in an emergency situation. The judge also said that had it not been that emergency pandemic environment, the consultation would almost certainly have been unlawful for the failure to consult with the Children's Commission and the group, the wider group. And she started from Lord Reed's comments in Moseley, which reflect the fact that the nature of the proposals that are being consulted on and the context in which the consultation is taking place are relevant factors in determining the nature and scope of a consultation. And that led to the judge to conclude, as I've indicated, that in the particular circumstances of the emergency that the pandemic represented, the slightly less or the considerably less extensive consultation, and including the failure to consult with the Children's Commissioner and the rest of the group, was not unlawful, although it would have been in normal times, in quotes. The Court of Appeal, when the case went there, as you'll see, the appeal is successful, and the Court of Appeal, before it reached its decision, recognised the emergency situation in which the decisions under challenge have been taken, and it grappled with the issue of whether the Secretary of State had been under a duty to consult, because that was one of the issues that was very much live at first instance as well, and concluded, we'll look at this in a bit more detail in relation to one of the later slides, but concluded that there was a statutory duty to consult, but also said, regardless of whether there was a duty to consult, the Secretary of State had chosen to consult, and having chosen to consult, Secretary of State had to follow the normal principles which and meet the requirements associated with consultation normally. So on to the next slide, please. The Court of Appeal, this is continuing the analysis of the Court of Appeal. The Court of Appeal said that the duty to consult arose in three ways. There was a statutory duty, as you can see in that first sub-bullet point. There was a duty by virtue of the established practice of which evidence had been provided that consultation was carried out with the group, including the Children's Commissioner, when changes of this sort were proposed. And there was a requirement to consult, a duty to consult out of fairness, a sense of fairness, because of the significance of the impact of the amendments on vulnerable children, a fact that had been accepted by the judge at first instance, as I've said, as well as recognised by the Court of Appeal. And there's one of the key propositions which I've referred to already, but let's repeat it. The Court of Appeal, if consultation happens, whether it's mandatory or not, it must be done properly and fairly, and there's case law, Coughlin and other cases to support that proposition very clearly. If we could move on to the next slide, please. So the Article 39 case was one of the first, if not the first, to go to court. A couple of others which it's worth mentioning. Sure. This is a case which involves a challenge to proposed modifications and reductions of local authority duties in relation to the provision of education and healthcare for children and young people. I apologise for all the acronyms in that first sub-bullet point, with special educational needs and disabilities. As you can see, the decisions taken and challenged in this case were decisions taken either by statutory notice or by secondary legislation, and they were taken in April and May 2020 and applied in England only. The secondary legislation relaxed certain time limits in respect of duties, things that had to be done in relation to the children affected by these proposals, but the amended, the proposals would have effect only for a relatively short period of time. They would cease to have effect on the 25th of September 2020. The statutory notices changed the duty to make provision under primary legislation to a requirement to use reasonable endeavours to make that provision. And those statutory notices, or the changes that they would effect, would ultimately be relevant and in place for the period from May to July 2020. There was a rolled up hearing in July 2020 to consider these issues, and ultimately there were two elements to the challenge that I want to just mention very quickly. First of all, a dispute as to the existence of the duty to consult, and secondly, this challenge to the Tameside duty to make reasonable inquiries. It was said in this case that no reasonable decision maker could act without consulting the children affected and their representatives, and permission was allowed in relation to that aspect of the claim, but ultimately the claim itself was refused. There had been contact with stakeholders, but the urgency of the pandemic meant that full consultation was not appropriate. Representations had been heard from all sides, it was felt. As far as the Tameside duty was concerned, the court refused permission on that issue and said that the argument on that point was simply, or the case on that point was unarguable. The circumstances of the pandemic made the need for change to the statutory duty obvious, even without the need for such inquiry. And there were further grounds of challenge on that case, which I won't deal with. And given the shortness of time, I'm also not going to go into the detail of the community action case, I think, but we will obviously circulate these slides and you can have our notes in relation to that, that matter. So if we can go on to the next slide. Stuart, do you want to pick out any points there particularly?
It's just to say, I mean, we quite like the phrases consultation on demand, and you know, if we're to sort of summarise everything that we've talked about, literally in one bullet point, it's probably that. it's that you know, people can come along, they can watch, they can participate in a way that they weren't able to do. The fundamentals of the consultation around the role of local councillors, community groups, hyper-local papers, websites, etc., are the same, but you still play a role, and we still have to work with them. So I think probably on that note, we'll wrap it up. I'm not sure we've got any time for questions, but I'll fully around for questions on email or anything else if you want to send us anything. Deborah, thank you.
Yes, unfortunately, we have now run out of time, but please do get in touch with them directly if you would like to ask a question, and all of the contact details will be in the handout. So just a quick note from us to say that we're still doing work around the Model Code of Conduct. Our judicial review on the restriction of public sector exit payments was granted permission to proceed, and we have a hearing date of the 24th and 25th of March, so watch this space. Parish Council Toolkit is almost completed and is due to be launched mid-February, so another one to watch. And as we speak, we're working really hard on your behalf to try and ensure the extension of the virtual meeting provision beyond the 7th of May. So just a few things there from LLG. Next webinar on the 27th is planning for the future and what's happened since the consultation closed. So that'll be quite an interesting one, worth joining. So all that remains is now for me to thank both Matthew and Stuart for what has been a fantastic presentation, and to thank you all for joining us today. So thank you, and it's goodbye from me.
Thank you very much.